Welcome back to Big Law University. Today we are going to be learning about business associations, and today's topic is going to be the creation of an agency relationship. This is the no nonsense tutorial. All right, so let's get into it. The creation of an agency relationship. Now, this topic sounds complicated because legal terminology makes simple concepts sound harder than they really are. So forget about the fluff. We're going to be doing this with no nonsense. I'm going to break this down so you understand who can be a principal, who can be an agent, how the relationship is created, and where the agent's authority comes from. So pay very close attention because these concepts show up throughout business law. So let's get started. Number one, definition and requirements. So you might be asking yourself, Mr. Big, what is an agency relationship? And I'm going to tell you exactly what it is. It's very simple. A principal authorizes an agent to act on the principal's behalf. That's the foundation. The authorization can be expressed or implied. The principal is the person or entity being represented. The agent is the person acting for that principal. For example, you own a company. You authorize someone to negotiate a deal on your behalf. You're the principal, they are the agent. They are acting for you. That's agency. Now, here's where you need to pay very close attention. So listen up. Not everyone has the legal capacity to be a principal, and the capacity requirements for a principal are different than those for an agent. Capacity of the principal. A principal generally needs the capacity required to enter into a contract. And here's an important distinction. The relevant time for measuring the principal's capacity is when the agent acts, not necessarily when the agency agreement was created. That's a detail worth remembering. First, the principal generally must be an individual or a recognized legal entity capable of holding rights and understanding obligations. That can include corporations and partnerships. Now, let's talk about minors. Generally, a minor does not have the same contractual capacity as an adult. So ordinarily, a minor cannot simply appoint an agent and expect every action taken by that agent to be permanently binding. The minor may be able to disaffirm the appointment or actions taken by the agent, but there are exceptions. One major category is necessaries: food, shelter, clothing. The law can treat those obligations differently, and some states have created special rules for minors working in industries such as entertainment. So don't make the mistake of memorizing one sentence and ignoring the exceptions. You need the rule, and you need to know when the rule changes. Next, mental capacity. There's another requirement. Mental capacity. A principal generally needs enough mental capacity to understand the nature and consequences of entering into the agreement. If the principal lacks the capacity, the agency appointment and actions taken by the agent may be subject to disaffirmance or later ratification. So here's the rule. A principal generally needs contractual capacity. Keep that in your head. Capacity of the agent. Now, the rule changes. Generally, almost anyone can serve as an agent. A minor can potentially serve as an agent. A person who lacks the capacity to enter contracts for themselves can potentially serve as an agent. Now, you might be asking, well, Mr. Big, why is that? And I'm going to tell you exactly why. That's because the agent is acting on behalf of the principal. The agent is not necessarily entering the transaction for themselves, but there are still restrictions. Dual agency. One restriction involves dual agency. That's when an agent represents both sides of a transaction. Obviously, that can create a conflict of interest. Some states restrict dual agency. Where it is permitted, the parties may need to provide informed consent, and in some jurisdictions, that consent may need to be in writing. So if you're representing both sides, you do not get to keep that information hidden. The parties need to understand what they are agreeing to. Licensing. Next is licensing requirements. So certain activities require an agent to hold a professional license. Real estate is a very common example for you realtors out there. If the law requires a license, you need the license. It does not matter how confident you are. It does not matter how experienced you think you are. The legal requirement controls. Non-delegable duties. Finally, some duties are non-delegable. That means the principal personally has to perform them. The principal cannot simply transfer the responsibility to an agent. If the duty is personal to the principal must perform it. That's the rule. 2. How is an agency relationship formed? Now we get to the heart of the topic. How is an agency relationship actually created? Here's the first rule you need to remember. Agency requires consent from both parties. The principal must consent, the agent must consent, both sides. And that consent can generally be demonstrated through words, writing, or conduct. You do not necessarily need some elaborate formal agreement. Sometimes the parties' conduct is enough to establish the relationship, but sometimes the law requires a writing. And this is where you need to pay very close attention. When is a writing required? The general rule is a writing is usually not required to create an agency relationship, but there are exceptions. Some jurisdictions follow what's called the equal dignities rule. Under that rule, if the underlying transaction must be in writing under the statute of frauds, the agency agreement may also need to be in writing. So do not make the mistake of saying agency relationships never require a writing. That's too broad. The correct approach is usually no writing is required unless the law requires one. That's the distinction. Consideration is not required. Now, here's another point. Unlike most ordinary contracts, consideration is not required to create an agency relationship. An agent can agree to act completely free. That person is called a gratuitous agent. So do not assume money has to change hands before an agency relationship can exist. It does not. Number 3, actual authority. Now, we're getting into one of the most important concepts. When the formal requirements for creating an agency relationship are satisfied, the agent can receive actual authority. Actual authority means the principal has actually given the agent authority to act. The principal authorized the agent. That's actual authority. But here's where it gets very interesting. An agent can sometimes have authority even when the principal did not actually give the agent that authority. How? Apparent authority. Number 4, apparent authority. Here's the situation. The principal says or does something that causes a third party to reasonably believe the agent has authority. The third party relies on that appearance of authority. Now the principal may be bound. And this distinction is extremely important. Apparent authority comes from the principal's manifestations to the third party, not simply from what the principal privately told the agent. Here's an example. You own a company. You privately tell your employee, do not sign contracts over $10,000. But then you repeatedly send that employee into negotiations and present that employee to customers as someone who has authority to make deals for your company. The customer does not know about your private limitation. The customer reasonably believes the employee has authority. Now you may have a problem because from the customer's perspective, you created the appearance of authority. That's apparent authority. Remember that distinction. Actual authority comes from the principal to the agent. Apparent authority comes from the principal's manifestations to the third party. Know the difference. 5. Agency by estoppel. Agency by estoppel. The basic principle is straightforward. A principal may be prevented from denying an agency relationship when the principal caused or allowed a third party to reasonably believe that an agency relationship existed. This can happen when the principal intentionally or carelessly creates that belief. It can also happen when the principal knows about the third party's belief and fails to correct it, even though the principal knows the third party may rely on it. So think about it this way. You create the appearance. You knew someone was relying on it. You failed to correct it. The law may prevent you from simply walking away from the consequences. That's agency by estoppel. Number 6, agency by operation of law. Finally, an agency relationship can arise through operation of law, and this one is very straightforward. Sometimes the law itself creates the agency relationship. No private agreement is necessary. For example, some states have non-resident motorist statutes. Those statutes can authorize a government official to act as an agent for an out-of-state driver for purposes of receiving service of process. The agency relationship exists because the law creates it. That's an agency by operation of law. Now, to summarize this, let's make this very simple. If you're preparing for an exam, remember these points. Number 1, capacity. A principal generally needs contractual capacity. An agent generally does not need the same level of capacity. Number 2, consent. An agency relationship requires consent from both the principal and the agent. Consent can generally be expressed orally, in writing, or through conduct. Number 3, writing. A writing usually isn't required, but certain circumstances and state laws can require one. Number 4, consideration. Not required, an agent can act for free. Number 5, actual authority. The principal actually gives the agent authority. Number 6, apparent authority. The principal creates a reasonable appearance to a third party that the agent has authority. Number 7, estoppel. The principal may be prevented from denying the agency relationship when the principal created or allowed a reasonable belief in the agency relationship and the third party relied on it. Number 8, operation of law. Sometimes the law itself creates the agency relationship. That's the framework. Don't try to memorize all of this as disconnected vocabulary. Understand the structure. Ask yourself, who is the principal? Who is the agent? Did both parties consent? Did the party have capacity? Was a writing required? Where did the agent's authority come from? Actual authority, apparent authority, estoppel, or was it operation of law? Once you start asking these questions, the topic becomes much easier because the real issue is simple. Who has the authority? Where did that authority come from? And who is legally bound by the agent's actions? Understand that and you've got the foundation for the creation of an agency relationship. This is Big Law University. Know the law, own the room.